At this event, those of you who have been here before know that we often use a quotation from Dr. King's body of work as a launch point or a touchstone to reflect on Dr. King's legacy and also to reflect on what those words mean for law and society today. This year's quotation is, "Law and order exist for the purpose of establishing justice, and when they fail in this purpose, they become the dangerously structured dams that block the flow of social progress." Now that quote comes from a letter from a Birmingham jail, an open letter written in April of 1963. King's letter responded to another open letter titled "A Call for Unity" that was written by 8 prominent moderate and liberal clergymen in Alabama. Those clergymen all agreed that social justice was critical, and certainly the injustice that existed in Alabama at the time was critical and important, but they also at the same time argued that racial injustice should be fought in the courts and should not involve community outsiders. They thought the civil rights movement was extreme, and they deplored the tension that it created. King's response letter reminds us of what civil discourse looks like. It exhorts us to distinguish just from unjust laws. And it explains why waiting for justice is a privilege that those who experience the affront of injustice can't exercise. It puts justice at the center, at the core, at the heart of the matter. As members of the legal profession, we understand the critical importance of the role of law. We know it is essential to providing avenues for justice. We can all point to countless ways throughout history in which lawyers have used the law to gain justice for individuals and communities. Yet at the same time, we can also understand that our legal system manifests structural injustice, biases in administration, and complex challenges in how we define and bring justice for all persons. Now, Dr. King's words call on us to think critically about how our systems and structures, including the legal system, can act as a dangerous dam that blocks the flow of social progress. So educating ourselves on bias and racism, identifying structural barriers to justice, supporting a more inclusive legal profession, advocating for change in law and policy and other action are all important. And we all have a role in transforming how the rule of law can better achieve equity and racial justice. Here at Minnesota Law, we believe in a foundation of critical thinking and skill development about law and legal systems through teaching, research, and scholarship, and engagement. Our faculty, staff, students, alumni, and supporters are called to continue the work of justice, to take action and to lead, and to make an impact in the profession and the world. Here at home and globally, I see our Minnesota Law community working both within and continually transforming the legal system to expand justice. And today, we are honored to have 4 of our distinguished alumni, 4 great lawyer leaders to inspire us and guide us. Joining us first is retired Judge Pamela Alexander, class of '77. Judge Alexander worked for the Legal Rights Center and as a Hennepin County attorney, where she was the first African-American female prosecutor in the state before being appointed to the Hennepin County District Court in 1983. She retired from the bench in 2018. Judge Alexander, we are thrilled that you are here with us today. Welcome.
I'm thrilled to be here. Thank you so much.
And next, I welcome Chief Judge Todrick Barnett, class of '92. Judge Barnett worked as a Hennepin County public defender and as a prosecutor for the Hennepin County Attorney before being appointed to the Hennepin County District Court in 2006. And effective July of 2020, Judge Barnett was elevated to Chief Judge, making him the first Chief Judge of color in Minnesota. Welcome, Chief Judge Barnett. Thank you for being with us today.
Thank you. I'm excited to be here today. Thank you so much.
And our next panelist is Chief Public Defender Cassius Benson, class of '96. Mr. Benson worked for the Public Defender Service in Washington, D.C. and the Hennepin County Public Defenders before starting his own criminal defense firm in 2002. And earlier this month, Mr. Benson became the Chief Public Defender for the Hennepin County Public Defenders. Welcome and congratulations on your new appointment. Mr. Benson, welcome.
Thank you, Dean. I'm happy to be here as well.
Great. And our final panelist is Judge Paul Fineman, class of '85. Judge Fineman serves on the Court of Appeals in New York, which for those of you who may not be familiar with the New York state system, that's the name for New York's highest court. Prior to serving as a judge, Judge Fineman worked for the Appeals Bureau and Criminal Defense Bureau of the Legal Aid Society in both Nassau County and Manhattan in New York. A judge since 1996, he has served on the Civil Court of the City of New York, the New York Supreme Court, which is the statewide trial court, and the Appellate Division prior to his current post. Governor Cuomo nominated him to the Court of Appeals in June of 2017, and he has served on that court since then. He is also past president of the International Association of LGBT Judges. Thank you so much for joining us, Judge Fineman. Welcome.
It's a pleasure to be here with you all.
Now today, our panelists will be led in discussion by our moderator, who is 3L student, Marilos Cabrera, who is from our Diversity and Belonging Affinity Council. She has prepared a number of great questions. She's also solicited and received questions from our law students. And so we're going to have a great and rich discussion today. Before we begin, just a few housekeeping notes. Today's webinar is being recorded, and the link to the recording will be shared via email to all registrants following the event. We have live auto captioning enabled, so please check on the live transcript feature at the bottom of your Zoom screen to view or to hide the captions throughout today's discussion. And we'll reserve time at the end for our panel to address questions submitted via the Q&A feature, which is found at the bottom of your Zoom screen. So at this point, please join me in welcoming all of our panelists and our moderator. Marilos, over to you.
Thank you, Dean Jenkins, for that introduction. And thank you to our panelists for being here. It really is an honor to get to speak with you all today. So before jumping into questions, I'd like to reread the quote that's grounding our conversation today, because I think it's important to have it at the forefront of the conversation and to keep in mind the context in which it was written. So the quote reads, "Law and order exist for the purpose of establishing justice, and when they fail in this purpose, they become the dangerously structured dams that block the flow of social progress." So in the interest of time, I'd like to dive right into questions related to the quote. And my initial question is, was Dr. King right? Was law and order really created for the purpose of establishing justice? I think many students feel that law and order and justice rarely, if ever, go hand in hand. And that begs the question, were they really ever meant to? Cynically, it can seem that law and order may be used as a tool to control rather than one to promote justice. So Judge Fineman, I'd like to hear your thoughts.
How to unmute myself. So like many things in life, I think two things can be true at the same time. And I think that that's the case here. And if you actually look at the quote, it recognizes that law and order can in fact be used to establish justice. I know that that has happened throughout history, as the dean already mentioned, and I think that using the courts, it's one of the reasons I actually went into the profession. It is often a viable tool for justice. Now, of course, any system, including courts and including legislatures and executive branch, is dependent on the commitment and the good faith of those who are the legislators, the judges, and the executive. And that's where you get into trouble sometimes with the second half of the quote, where he's pointing out that depending on who's controlling those institutions, they become a dam. And like so many things in life, two things can be held true at the same time.
Certainly. Mr. Benson, do you have something you'd like to add on that?
Yes. In answer to the question of, does law and order and justice basically, do they go hand in hand? The concern that law and order is something opposite of justice. When one looks at the letter Dean indicated, if one looks at just laws versus unjust laws, moral versus immoral, they definitely go hand in hand. It's, for example, in our context of what we do, broad policy considerations such as caging people or jailing people disproportionately, meaning based upon their race, based upon the circumstances they're in, disparities in sentencing. And I think Judge Alexander and all the rest of us are very aware of the drug sentencing laws and how they were, how they are now as well. So in the idea of law and order in the context of what I believe Dr. King was talking, that there is law and order, they're talking about just laws and orderly fashion and orderly application of those laws, in both the creation of the law in that it benefits everyone, and in the enforcement of the law. So as far as when law and order and the dams are created, it's a situation in my mind that we're no longer dealing with quote unquote law and order, we're dealing with unjust laws, improper order. And basically order is as he talked about the timing of things, it's always better to deal with, disproportionate sentences. It's always better to deal with, the killing of people of color by police officers at a later date in a more peaceful fashion. So in looking at it, I can easily see how a student may feel that, they never were meant to go hand in hand. But if you go back to the beginning of it, definitely, I think his quote is accurate. And when you look at the whole context of his letter, it's still applicable today.
Great. So if law and order can represent a dam to social progress, have we reached a point in time where the dams are starting to collapse? In other words, we're at an interesting point in time where racial tensions are high, general faith in law enforcement is low, and every day the media is exposing hypocrisy in our government and division amongst our citizenry. Do you think that this will lead to a point in time where the dams can start to collapse, or will these dams merely be reinforced or repackaged? Judge Alexander, I'm curious to hear your thoughts.
Thank you, and I'm anxious to give you my thoughts. One of the things that I think that we need to look at, and I look back at Justice Thurgood Marshall, who said that, law is ever changing. It is also something that we with a legal education can figure out how to move forward. I think, everybody is looking at this point in time as being unique. It really is not. And since I'm the only one on the panel who was alive and a whole adult during the 60s and do remember the marches and some of the things there that are very similar to what's going on now. So if we don't know our history, obviously we're bound to repeat it. And we are repeating this because we didn't get it right then. And so I'm hopeful that we will get it right now. We know that laws have to apply equally to everyone. It has not been that way in the history of this country. And now I am anxious for this new group and all of you law students who are moving forward to figure out a way to make sure that we make the Constitution really apply to all. And to do that, we can make strides. There were a number of strides that were made after the riots in the 60s. There was many laws that were changed and things that were done. So it does not have to necessarily be a dam to progress. It can actually open the floodgate to progress if we have the moral authority and the moral fortitude to get it right. And I think right now we need to get it right.
Judge Barnett, would you like to add anything to that?
Yes, I think Judge Alexander is exactly right about, our history and looking at the dams that Dr. King talked about, right? I mean, when we think about our history from the first time that slaves started to revolt against their master, you look at the Native Americans fighting for their land, or you look at our civil wars or civil rights movements or Me Too movements, or, we look at the death of George Floyd and many others, all the way up to the day. I agree with Judge Alexander, history's repeating itself, but each time it seems like we're pushing on these dams for social progress. And sometimes it crumbles a bit. And like Judge Alexander is talking about, sometimes we can open these gates and start to make more progress. I really do think that this time is different. I think that we have many more non-people of color joining peaceful protests. I think other people besides people of color are asking for change. I agree that we have a number of younger people demanding more from its leaders. People are waking up to the notion that social progress benefits all of us. And it seems like each time that we get to this point, we're still asking for respect and human, dignity for folks. And so I really do think that the dams are collapsing, and it's a matter of whether or not it's going to collapse fully or it's going to come back in a different form. So those are my thoughts. Thank you very much.
Yeah, so if the dams are collapsing and we're moving towards social progress, I'm curious to know, Mr. Benson, what are your thoughts? If we are having meaningful social progress in 2021, how do we ensure that law and order starts to look and feel more equitable? Are there tangible changes that need to be made? Are there, what are some of the biggest dams that are blocking the social progress right now?
Sorry, let's go to the biggest dams in the context of what Dr. King was talking about. I think there's a consensus, and George Floyd has actually obviously been mentioned. In that vein, I think there's consensus among people that his killing was wrong. If you look at, I think if you poll a majority of people, they say it's wrong. The consensus as far as, or at least looking at the dams and law and order, is a matter of how do we go with law and order to show or implement that consensus to say, okay, how are we going to stop this? I think in a large section of the community, while they say it's wrong, there's also it's tolerable. There's going to be a reaction that's going to stop such things. When we look at, I think if we look at the law, like we look at the laws and whether we look at what is just about the situation versus what is not just. In this case, it would be just to, for example, federal prosecution in addition to state prosecution. That's one tangible thing that could be done. But that's, I think when we look at how, in this case, people of color are treated, and we expand it beyond even George Floyd, we look at the, we'll say we've used the term mass incarceration before. I will just give you a practical example in what we see in Minnesota. We see there's been a bail reform movement, but we see a large number of people being held in jail pre-trial. We see a large number of people unnecessarily having monetary bail placed upon them. It affects certain communities more so than others. So there's a number of things that we agree as a people, you know, that this is wrong. But the question about the impediments and the dams is like, not only what we're going to do about it, but how quickly we're going to act on it, how sincerely we're going to act on it, and how people are going to understand that maybe they'll be inconvenienced in what their worldview is, but we're going to go ahead and say, you know what, we're not going to cage people. We're not going to unnecessarily hold somebody for a property crime. All of these matters, and why I started, I suppose, with the George Floyd situation, is that in 2021 here, I don't know how much progress we're going to have. I agree with both judges, or Judge Alexander and Judge Barnett, that there are positive changes that have been made. There's social, there's a desire from the young and everyone else to say, we're going to go in and make these changes, but we're also kind of waiting to see what happens in this case, you know, that hit Minneapolis hard. We're waiting to see what the reaction will be, what the law enforcement efforts will be. So in a certain way, that is holding, kind of, we're in abeyance, kind of waiting and having a pause. But we also have to look at the other matters that are directly affecting, in my case, clients from our office, and these other social issues. So there's a method, we're making progress. I think I'll just wait, end of 2021 and see how much progress that actually is.
Wonderful. I think it would be a missed opportunity not to discuss the attack on the US Capitol on January 6th. I think that many students and citizens alike pointed out differences to the response of the attack on January 6th compared to the response to Black Lives Matter protests at the Capitol. Additionally, after the attack on January 6th, we saw a lot in the media and social media that the United States is not like this, or that the attack seemed like something that would only happen in a third world country. And certainly there were those that pushed against that notion and urged that this should be a wake-up call that the United States is in fact flawed. Judge Alexander, I'm curious to know what you think of all of that process and where we go from here.
I think that there has been a misconception that the United States has not been built on violence. It definitely has been. And so I think that people really need to start to take a real hard look at what we have been doing and in the past and how it is really manifesting itself now. There's always been a vast difference between how people of color have been treated in the country under the law and how others haven't, how rich people and more affluent and powerful people have been treated as opposed to poor folks and the people that Mr. Benson's office represents. And so we have always had a differentiated application of the law toward people of color. And actually it's been on the books, so people can go back and look at those cases and know that it's true. Segregation really wasn't ended until it was ended in my lifetime. So it's not necessarily something that I'm speaking of metaphorically. It's something that I actually saw and lived through. Sometimes I sit back and think about, how could people even accept segregation? I'm not even going to get back into slavery or the Black codes or anything that was actually tremendously horrific, but the United States has always had this in its past and in its history and has not really taught it well. And that's why I said in my beginning remarks that if you don't understand your history, you're bound to repeat it. Now I think that hopefully the young people are opening their minds to the fact that we are built on a flawed system. And the only reason that the system will work is if we have the will to make it equally apply to everyone. And we need to have that will right now. There is no reason to treat people differently. And I'm very curious, especially after this assault on the Capitol, to see if in fact we let the rich and powerful off again with no accountability, whereas if we know if I had done it, I would be dead right now. So the problem is that the powerful and connected should not have one set of laws and people of color and poor folks have a different one. We have to have an actual system of accountability. I'm waiting to see what this Congress does, because it is going to tell us loud and clear whether or not we're going to treat everyone equally under the law, which includes accountability, or not. And so we also have to really face the fact that we have never been a perfect country. We have always been a flawed country, and we need to work toward fixing those flaws.
If I could just pipe in for 1 second, and that's just, I do agree with much of, if not all, what the judge just said. But that said, she made a reference to the elimination of segregation, and I'm sure she meant de jure segregation, because we all know that de facto segregation is alive and well.
It is.
And without getting into politics, as a sitting judge, when you make an appeal to people about the safety of your neighborhoods and what that's going to mean, that's an appeal to maintain de facto segregation.
I wholeheartedly agree, Judge.
I think part of this discussion, when we talk about the Capitol and other things, in Dr. King's letter from Birmingham jail, one of the things that I found interesting and applicable to what we're seeing now is that he said that those people or those of us who engage in non-violent direct action are not the creators of tension. He said, we merely bring to the surface the hidden tension that is already alive. And that's what we see. We know that under the surface, there's a lot of tension. And Dr. King in that letter talked about that this brings it out to the open to be dealt with. It brings it out to the point that you can't ignore it. You have to talk about it. You have to do something about it. And so one of the things that he said in that letter was about exposing these injustices and bringing light to the human consciousness. And that's what's important, in that we're always going to have tension when we are looking to have progress, social progress, as we move that forward. So thank you.
Yes, thank you. And as I've been thinking about this a lot, I think your point on exposure is very true. I mean, I think there is a real danger of dismissing these incidents that we've had as just being unlike us or othering that. It's a real part of the moment in time that we are at. Um, so moving on to our next question, I think that many students feel conflicted by wanting to reform the criminal justice system or the legal community more in general, but also struggling with feeling that by choosing this profession, we are complicit in a system that is often intrinsically not equitable. So what advice would you have for those students who are struggling with this, or how to make sure that we aren't accidentally complicit by the time we get there? Judge Feinman, if you could start us off.
So this is an old question, do I work from within or from without? And I think people have to find where they feel that they can be most effective. Obviously, I don't think it's about being a lawyer or getting a legal education, because I think that can help you regardless of whether you choose to do it as an advocate, with an organization, whether you choose to do it, as a lawyer who just takes on particular clients and causes of action, certain causes through your client, or, to be perfectly frank, when I left the public defender, or what is the equivalent of the public defender in New York City, I first went to work for a judge, and then ultimately sought to become a judge. I was a law clerk for about 7 years to a judge. And there's a real difference between being an advocate and then sort of being the judge or being the judge's law clerk. And one of the reasons I did it is because certainly as a trial judge, and this has changed over the course of my career, but as a trial judge, I certainly felt that I had a lot of power and influence to try, within the confines of the statutes and the law, to achieve justice. What happens as you sort of go up the chain of command, if you will, of courts, is your jurisdiction changes, your constraints changes, and so, when I got to the intermediate appellate court, it was about error correction, but giving sort of leeway to the rulings of trial judges. It's like recognizing, well, there's not only one way to do things, and if they haven't really committed legal error, But the other thing that was true of our intermediate appellate court was that we had interest of justice jurisdiction. Now I'm in the Court of Appeals. We have no factual review power. We have no interest of justice jurisdiction. This is not necessarily true in other states. It depends on how your constitution and your judiciary law are written. And it's actually very confining. And I actually felt in many ways I had more power to achieve justice as a trial judge than as a judge on the high court. And of course, to get anything accomplished in a intermediate or high court, you need to bring along a majority. So not always easy. And you tend to do it in baby steps, as opposed to if you become an advocate or a legislator, you can do things in much broader sweep. We've had significant bail reform legislation in New York. We've had significant criminal justice reform, and now that their legislature now has a absolute veto-proof majority in both houses, people are expecting 2021 to bring even more criminal justice reform. But I would also emphasize, because there has been a lot of discussion of criminal justice here, so many of these issues go right across the board into the civil justice world. And, whether it's housing, whether it's, access to benefits and just food and things that you need for daily living. So I think I'm probably way over time. So, but I do think that becoming a lawyer does not necessarily mean that you can't work in some fashion towards social justice. And that's true even for those of you who decide to go the big law route. A lot of our backgrounds, as far as I know, from what I heard, are in the public sector. But some of the best cases that are argued in our court on behalf of poor folk and others are done by pro bono lawyers. So everyone can do something. You can't do it all, but you can do something. And that's what I would say. Use your legal education to do something to make the world a better place, and this country a more just country.
What I would add to that would be you can't make change if you're not in the room. So if you're not in the room, you certainly can't do anything. And so use your legal education in a way that can promote and advocate justice. As judges, obviously, there were certain things that you can and cannot do. I did leave the bench for a while and did head the Minnesota Council on Crime and Justice, where we made a lot of legislative changes and a lot of changes to legislatively and through the executive branch. And it was very rewarding for me to be able to lead that organization and to make those very positive changes. However, I was a criminal defense lawyer, I was a prosecutor. There are things within those offices that can also be done that can move justice forward. So you can use your legal education in many, many ways, but you certainly cannot do that if you're not in the room and you're not hearing the discussion. I was able to obviously work on the Race Bias Task Force as a judge. I loved that experience. We did make some very meaningful change and made a number of recommendations as to how the system can improve. And I know that Judge Barnett is continuing with those efforts as well. And so I think that there are so many things that you can do, but you certainly cannot do it if you're not allowed in the room or to raise those issues. So I would say grab your legal education, jump in, and try to do whatever you can to improve the system, because you're the only ones that can really do it.
But that's, Judge Alexander, that's what I think here in Hennepin that's apparently different, is that historically we've talked a lot about these issues with no action. And I think now what we're seeing is that these discussions from all of our justice partners are happening, and they're saying, okay, so now what do we do? What can we do? And I think we see more engagement with the community, more of an appetite to be proactive and not reactive. And that's why I think that we're at a different point in where we're going in the push for social change from within. I think that this work is not for everyone. Some people might feel more comfortable in a different setting, and like Judge Alexander talked about, making change within the prosecutor's office, making change within the public defender's office, probation, the courthouse. It's like Judge Feynman mentioned, where do you feel you fit? Where do you feel comfortable to make that change? And you might feel differently in the future, but where are you now to be helpful? And one of the things that we know is that you have to speak up. And in Dr. King's letter again from Birmingham, he talked about that, and he talked about the fact that he was afraid that he would not only have to repent for the hateful words and actions of bad people, but the appalling silence of the good people. And so wherever law students are or non-law students are, it's speaking up to make change. And I think that the late Representative John Lewis, said it best, and that is, never be afraid to make some noise and get in good trouble, but necessary trouble. So I think that's where what the law students should think about.
If I can,
If I could,
I'm sorry. Go ahead. I didn't mean
thank you. Yeah, if I could add as well, I concur with the sentiment of the other panelists. But I wanted to address this, that the concern about being complicit in the system, it is not an equitable system. But as Judge Alexander said, you can't make any changes if you're not in the room or in the system. And we have, I've been a trial lawyer, a criminal defense lawyer all my career. Now I have the pleasure of leading an office of excellent criminal defense lawyers. But whether it's the private defense bar, whether it's the public defender, whether you join the system as a prosecutor and try and make changes that way, whether you're eventually a judge, it is completely a requirement. If you want to make an inequitable system equitable, you've got to be involved. So if you're not in the arena, and to echo what Judge Barnett just said, remaining silent, not trying to address the issue, you become maybe even a bigger problem. If you look at the letter from Dr. King, that might be the bigger problem, being moderate and not taking a position. So I'd add that.
Yeah, I just wanted to add anecdotally what's going on in New York. So we in the aftermath of George Floyd, our chief judge appointed Jay Johnson, who obviously was, among other things, Secretary of Homeland Security in the Obama administration, to undertake a systemic operational study of the New York courts and examine issues of systemic racism, both in our procedures and whatnot. And he issued a fairly comprehensive report in October. And those are being fully, with recommendations being fully endorsed by the chief judge and undertaken. But the point is, you have to get all the participants in the criminal justice system. And that wasn't just a report about criminal justice. It was a whole system, civil, family, everything. You need to get all your participants actively involved. And one of the wonderful things that I've been lucky enough to do is in the summer, there's a separate task force called the Justice Task Force in New York, which is specifically criminal focused. And it was created not by the current chief judge, but her predecessor to deal with the issue of wrongful convictions. Its scope has expanded, and there are some wonderful changes that have come about, including, and what they do is it brings together prosecutors, defense lawyers, both public and private, and it brings together the police and other law enforcement. It brings together victims' rights groups and representatives of all the participants in the criminal justice system. And there's a lot of disagreement, but ultimately we make recommendations, and they can be recommendations to the chief judge, to the legislature, to the executive. Happily, many of those recommendations are taken into account and have led to such as changes in how you interrogate and videotape confessions, things of that nature. But it was by having all the people in the room, as Judge Alexander said, and having all of those people at the table that's happened. And it just so happens that well before George Floyd and before I became chair, they were tasked by the current chief judge of looking at the issue of racial disparities, whether it's in charging, sentencing, pre-arrest, pre-arraignment diversion program. And you know, we're working on a lot of recommendations. We just made a whole series of recommendations regarding what's called the summons process in New York City, which things such as for drinking alcohol on your stoop and laws that are clearly, just the numbers make clear, are being enforced disproportionately against people of color. What I found in dealing with these new, my new role of meeting with it, is there are people who are dedicated to making it a more equitable system in the prosecutions, the various prosecutors' office, in the police department, in all of the agencies that are involved. And it's a matter of bringing all that goodwill together and having a seat at the table, as Judge Alexander says. So sorry that went on long.
No, thank you. That was all wonderful and gives
Yeah.
me hopefully.
You can read about it. They have their own website, the New York Justice Task Force. Read about what we're up to.
Well, wonderful. That gives me and I hope other students a lot of hope that there are meaningful ways that we can impact the legal system upon entering it. On that note, we are now transitioning on to student questions. And students, you're encouraged to put them in the Q&A. Otherwise, I saw one question here that Mr. Benson started answering. So if you want to talk about that and others can jump in. But the question was, how can law schools prepare law students to help make necessary changes in the legal system? Mr. Benson, why don't you start us off?
Yeah, what I believe is that law schools not only giving you the academic education, but the opportunities through either clinical or practical experience, opportunities that will allow you to and take advantage of the opportunities to engage with the clinical programs. They give you access to clients, give you access to the community that allows one to see what the communities who are affected by this inequality. To have that access and to get a firsthand look at what changes need to be made. And the law school is an excellent place for that. Obviously, there's an excellent clinical program. The social justice things are doing programs like this. The opportunities are there. So that's what law schools need to do. And law students, I would say, need to take advantage of the opportunity to engage not only legally with the education, but also with the community that's affected.
If anyone else would like to jump in with thoughts, feel free.
I would agree that everybody should try to get involved in some clinic. I'm always amazed when I get my alumni magazine from the law school about all the wonderful things that have been done through the clinics and through other organizations at the law school, whether it was immigration related, whether it's public defense or public prosecution. So I just keep at it. And I think that is a valuable experience. One of my former clerks, who's a Minnesota grad, actually I've had 2 Minnesota grads as clerks, that they, will both tell you that whether it was their summer internships or their experiences with the clinics, those were valuable, not only for understanding the law in the abstract, but for understanding how it applies to people's lives. And, I have said this many times. I used to say it when the intermediate court here does the swearing in, not the high court of new attorneys. And so when I would have the opportunity to address newly admitted attorneys, I would explain that in my view, the law is a helping profession, and that is their obligation, whether it's through what they actually do day to day or through pro bono work.
I would also encourage law students to get involved with nonprofits in the area that really deal with these particular that deal with disadvantaged communities. One, because that gives you a different perspective from what you may see in your everyday life, or what other traditional kinds of summer and legal internships and clerkships give you. I think some of the local nonprofits will give you a different eye, and you can really see and still help move the community forward through that avenue as well. So everybody is not necessarily going to get a judicial clerkship or something like that. But, I clerked at the Neighborhood Justice Center, the Legal Rights Center. I had many clerks at the Council on Crime and Justice. So there's other places that you can go that will give you a very rich education and background that you can take forward and take with you throughout your career, that will kind of hone you toward the things that you feel passionate about. So first of all, figure out what it is you're passionate about, and then second of all, act on it.
Thank you. Sometimes figuring out what we're passionate about is the hardest part, or what we're not passionate about. So Judge Barnett, there's another student question here that I'd like to put your way. Would you please address the role of prosecutorial discretion in criminal justice reform? And if the other judges have thoughts, they can jump in.
Being a former prosecutor for a short time is huge. Being able to, for instance, not pursue criminal charges prior to them ever entering the system is huge. And it's only as good as your boss allows you to do it. And the reason I say that is it doesn't make a difference if I'm not going to charge the case if they take it down the hall to someone that will. So being able to have that discretion is just huge, and how we use it equitably is important. And so I think it's a powerful tool that prosecutors have.
I'm going to add a little bit to that, because I think I've given a lot of thought as to prosecutorial discretion, how that works. I was also a former prosecutor for a short period of time as well. I do think that needs to be examined a lot, because we need to really take a look at how racial disparities are creeping into that discretion. And so that needs to be studied and examined, and we need to make I think some changes need to be made around that. It is extremely powerful, but it can be used powerfully in the wrong way, as well as ways that it could be right. So we definitely need to make sure that prosecutors understand their oath, which is to carry out justice regardless And that means not charging cases that don't need to be charged, as well as charging cases that do. But we also have to make sure that we're not doing it in a racially biased way. And I think that that's something that prosecutors across the country are talking about right now. There's a number of them that are examining that. I talked to a judge friend of mine in Cleveland who was telling me about some reform efforts on their part in Ohio. So I do think that this is something that needs a lot more discussion. And I think the way that you go about it can make all the difference in the world. So we have to be sure, however, that we're being just and equitable to everyone. And I think that is something that needs to be looked at.
Yeah, one of the things that we're finding in our Justice Task Force has to do with diversion programs, a pre-charging diversion program. Part of the problem is that it is very easy for racial disparities to creep in because, and that partially depends on who makes the decision to divert. So up in Albany County, you know, the police officer pulls you over on the street, whether it's a motor vehicle stop or something else, and it's the police officer who, they have this program called the LEAD program, who can say, you want to go off to, you know, get alcohol, whatever, some diversion program. And we're not really clear how that's monitored. Like, well, who does the officer decide? Is it just the white people he pulls over? Is it everybody? Is it uniform? So there are, you know, diversion is great, but it has to be done equally and whatnot. And then we've been looking around. We have 62 counties. We've been surveying them, and you know, there are real. I'm sure this is true in Minnesota too. Real difference in resources between cities, so places like Hennepin County, and rural communities that just because of how our things are funded here, a lot of it's done at the county level. And so you get into these disparities based on the resources of the prosecutors. So like New York County, Manhattan, has a lot of resources for diversion and making sure, you know, and dealing with the digital divide, because a lot of their diversion is done digitally, because they have great resources from their forfeiture asset programs. And they, you know, the DA, the current DA, Cy Van, has chosen to use a lot of that money for diversion. You go up to a rural county, they don't have that. And so there's a lot of inequity built into the system for how things are funded. It's very complex. But I remember as a young public defender being told more than once by, to follow up on Judge Burnett's comment, you know, I would say, really, you're going to do this? You're going to make this person, you know, get a record over this, you know, a bunch of socks, that, you know, and I just, the answer would be, I'm not, you know, my supervisor won't let me offer anything less, you know. So that is absolutely true what Judge Burnett says. Prosecutor discretion partially depends, particularly for young assistants, on who's overseeing them.
Thank you. I want to be sure that we're being respectful of everyone's time. So we have the other questions copied, and the responses to those might be shared in a post-event email next week. But I think at this time, we're going to have to cap student questions. So I'd like to thank everyone for attending the University of Minnesota Law School's 6th annual Martin Luther King Jr. Convocation. I want to give a huge thank you to our panelists for being here and dedicating their time. I'd like to thank Dean Jenkins as well for his participation in today's event.